Do I need a business operating agreement for my business in Oklahoma County? Technically, Oklahoma law does not require every business to maintain a written operating agreement. However, that does not mean your business should operate without one. Whether you own a single-member LLC or a company with multiple owners, an operating agreement can provide significant legal and financial protection. For many businesses in Oklahoma County, the operating agreement becomes one of the most important documents governing how the company operates, how disputes are resolved, and what happens if an owner leaves, becomes disabled, or passes away. What is an operating agreement? An operating agreement is a written contract among the owners of an LLC that establishes how the company will be managed and operated. Oklahoma law specifically recognizes operating agreements and allows LLC members to define many aspects of their business relationship through this document. The operating agreement often addresses issues such as ownership percentages, management authority, voting rights, profit distributions, capital contributions, buyout procedures, and dissolution procedures. While the Articles of Organization establish the existence of the LLC, the operating agreement typically governs the day-to-day relationship between the owners. Without an operating agreement, many disputes are left to Oklahoma's default LLC statutes, which may not reflect what the owners actually intended. Single-member LLCs benefit from operating agreements too. Many business owners mistakenly believe operating agreements are only necessary when there are multiple owners. In reality, single-member LLCs can benefit substantially from having a written operating agreement. For a single-owner company, the operating agreement helps establish that the LLC is a separate legal entity, distinct from the owner. This distinction can become important if the business is sued or if a creditor attempts to argue that the LLC and owner are essentially the same person. Banks, lenders, investors, and business partners may also request a copy of the operating agreement before entering into certain transactions. Having a written operating agreement often helps demonstrate that the business is being operated as a legitimate and independent entity. Multi-member LLCs should almost always have one. For LLCs with multiple owners, an operating agreement is arguably essential. Many business disputes arise not because the owners dislike one another, but because they never discussed important issues before problems developed. A properly drafted operating agreement can address what happens if an owner wants to leave the business, an owner dies, an owner becomes disabled, additional owners are admitted, the business needs additional capital, and the owners disagree on major decisions. Without clear procedures in place, disagreements can quickly escalate into expensive litigation. Operating agreements help prevent business litigation. One of the greatest benefits of an operating agreement is that it can reduce the likelihood of future disputes. Many business lawsuits involve questions such as, who owns what percentage of the company? Who has authority to make decisions? How are profits distributed? Can one owner remove another owner? And what happens if an owner stops working for the business? A well-drafted operating agreement often answers these questions before a dispute ever arises. Preventing litigation is usually far less expensive than trying to resolve ownership disputes after the business relationship has deteriorated. Investors and lenders often expect one. Many lenders, investors, and financial institutions expect LLCs to have operating agreements in place. When applying for business loans, lines of credit, commercial leases, investment opportunities, and business acquisitions, you may be asked to provide a copy of the operating agreement. Without one, the transaction may become more complicated or delayed. For growing businesses, having an operating agreement prepared early can help avoid future obstacles. An operating agreement can protect family businesses. In Oklahoma County, many LLCs are family-owned businesses. Family members often start businesses based on trust and verbal understandings, assuming formal documents are unnecessary. Unfortunately, family-owned businesses frequently become the source of some of the most difficult ownership disputes. Changes involving divorce, death, disability, retirement, inheritance, or differing business goals can create significant conflict. An operating agreement helps establish clear expectations and provides procedures for handling future changes within the business. Every business has different needs. There is no single operating agreement that works for every company. The provisions appropriate for a real estate investment LLC may differ substantially from those needed for a construction company, professional practice, manufacturing business, or family-owned operation. Important considerations often include ownership structure, management authority, tax planning, succession planning, buy-sell provisions, and asset protection concerns. For this reason, many business owners choose to have an operating agreement specifically tailored to their circumstances, rather than relying on generic online forms. What happens if you do not have an operating agreement? If an LLC operates without an operating agreement, Oklahoma law supplies default rules that govern many aspects of the company. The problem is that these statutory defaults may not reflect what the owners intended when they started the business. In the event of a dispute, the court may be forced to apply statutory provisions that none of the owners ever considered. For that reason, many business attorneys view an operating agreement as one of the most important preventive legal documents a business can have. Oklahoma City business lawyers. An operating agreement is more than just a formality. It serves as the foundation for how an LLC operates and can significantly affect ownership rights, management authority, succession planning, and dispute resolution. Because every business is unique, owners should consider consulting with an experienced Oklahoma business attorney before relying on a generic operating agreement or operating without one altogether.
Contact an Oklahoma City business law attorney that you can count on. For a free consultation with the Kania Law, OKC attorneys, call 405-367-8710.